All right, so hey people, Russ Jensen. It's about 9:30 p.m. on the 15th of December, 2016, here in Salt Lake City, Utah. Now we're gonna start getting a little bit more of the meat and potatoes of things. Be making a series of videos to go along with the book, but we're start talking about our, I guess, our counteroffensive when we're doing counterclaims of any kind. When we start getting into engaging with the governmental authority and the primary aspects that has to be established by your governmental authority in these matters is jurisdiction. Now, I'm not going to go into a lot of the specifics of jurisdiction in this particular video because we're going to cover that in great detail in another one. But I wanted to cover this one briefly and tie it in with a fact that I spoke about the other day. We'll do this also about the whether or not the United States District Courts have jurisdiction and what that means if they don't, what that means if they do. But and I'll be putting up copies of these, well, my notes at the end of this video so you can pause them and read them and verify. But we're going to talk a little bit here about jurisdiction, the fact that it must be proven once it has been challenged. And jurisdiction can be challenged at any time. So I'll read a couple of lines from a few Supreme Court cases. This is one that happens to be out of Rhode Island or out of Massachusetts. It's the state of Rhode Island versus the Commonwealth of Massachusetts, 1838, very famous case. But however late this objection has been made or may be made in any cause in an inferior or appellate court of the United States, it must be considered and decided before any court can move one further step in the cause, as any movement is necessarily the exercise of jurisdiction. Jurisdiction is the power to hear and determine the subject matter in controversy between parties to a suit, to adjudicate or exercise any judicial power over them. The question is whether on the case before a court their action is judicial or extrajudicial, with or without the authority of law to render a judgment or decree upon the rights of the litigant parties. If the law confers the power to render a judgment or decree, then the court has jurisdiction. What shall be adjudged or decreed between the parties, and with which is the right of the case, is judicial action by hearing and determining it. Now, when a court has jurisdiction, it has a right to decide every question which occurs in the case. And whether its decision be correct or otherwise, its judgment until reversed is regarded as binding in every other court. But if it, the court, acts without authority, its judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a recovery sought, even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. Now, that's a United States Supreme Court case holding Elliott v. Pearsall, 1828. If any tribunal finds absence of proof of jurisdiction over person and subject matter, the case must be dismissed. Louisville Railroad v. Motley, another United States Supreme Court case. Okay? Now, we talked briefly, or I mentioned it, but I will go and we're going to put this up here. This is information that's been provided by Paul Andrew Mitchell, supremelaw.org, fantastic place. I'll put a link to it. I'm going to put up his writings in total. You get all the credit for this research and this work that's done, but it's been put together pretty well. So I'm going to quote directly from this also. We're talking about United States District Courts. Now, isn't that the place everybody gets prosecuted under federal law for tax cases, drug cases, interstate mail fraud, all kinds of different things? But the problem is whether or not United States District Courts have jurisdiction. Now, Title 28 is the part of the United States Code that talks about the federal court systems. And we find in there with research and study that there are two classes of federal district courts. One class for the federal zone, which is District of Columbia and the territories, and one class for the state zone. Now, in another segment, we're going to be talking about some of these rules of statutory construction, but one of those happens to be the inclusion of one is the exclusion of all others. And I can't pronounce it Latin, so I'm not going to try. Okay, but using that statutory construction rule of inclusion of one is the exclusion of all others, we can show that the phrase District Court of the United States refers to federal courts for the state zone, and the phrase United States District Court refers to federal courts for the federal zone. Now, federal courts are created by statute, and they can only recognize subject matters which are assigned to them expressly by statute. Now, for criminal jurisdiction, your controlled substance acts that people get prosecuted on, tax violations, all these different things, the controlling statute is 18 USC 3231. And that statute grants original jurisdiction to the district courts of the United States, but does not mention the United States District Courts. Now, isn't that the one that everybody's prosecuted in? Because if you know somebody has been, or you have yourself, with your paperwork, United States District Courts, that's where they take everybody. You know, remember what we just said. United States District Court refers to federal courts for the federal zone. Now, we're going to talk about that also, too, the difference between the federal zone, states, and jurisdiction, territorial jurisdiction, and how those things operate in law. What has to happen. You're talking about United States District Courts refers to federal courts for federal zones, federal territories. Okay, keep that in mind. Now, the statute, 18 USC 3231, grants original jurisdiction to district courts of the United States. It does not mention United States District Courts. Now, the inclusion of one is the exclusion of all others. Its omission by Congress must be inferred as intentional. Okay? So what's happened is that Congress has permitted the limited territorial and subject matter jurisdiction of the United States District Courts, which is federal courts for the federal zone only, to be extended unlawfully, unconstitutionally into the state zones out here and into subject matters over which said court has no jurisdiction whatsoever. Okay? District courts of the United States have criminal jurisdiction. United States District Courts do not. Now, for further proof of that fact, we can go look at 18 U.S.C. 1964A and 1964C. Now, what are those? Those are the statutes, they're Title 18, which grant authority to issue remedies to restrain racketeering activities prohibited by 18 U.S.C. 1962, RICO. Okay? Now, 1964A grants civil jurisdiction to issue injunctive relief to the district courts for the United States. Section 1964C grants civil jurisdiction to issue injunctive relief to the United States District Courts. They're both referring to the exact same subject matter, namely RICO, racketeering, influence, and corrupt organization activities. So it's two statutes, otherwise identical. Why did Congress need to enact two separate statutes? The answer is simple. One authority was needed for district courts in the United States, and the other was needed for United States district courts. Now remember, district courts for the United States refer to federal courts operate out here in the states. United States district courts refers to federal courts for the federal zone. So the problem here is that they've been prosecuting people in the United States district courts. Have no criminal jurisdiction whatsoever. Okay, there's no authority granted anywhere. Neither Title 18, 28, or even Title 5. Okay? Title 8 is criminal, 28 is the court systems, and Title 5 is your governmental organization employees. Now, we talk about jurisdiction has to be proved once challenged. Now, if they don't have criminal jurisdiction, and the language of the statutes of under RICO 1964, 1962 are for civil injunctive relief. Now, what is that? What is injunctive relief in a civil matter? It's a legal remedy that may be sought in a civil lawsuit in addition to or in place of monetary damages. So rather than offering money as payment for a wrong or a civil action, injunctive relief could be a court order for the defendant to stop a specified act or particular behavior. Now, the courts have come up with some rules for injunctive relief. The definition, certain requirements must be met. Okay, so they basically have four specific factors that they take a look at in deciding whether or not they're going to grant injunctive relief. And number one is whether there's a reasonable likelihood that the lawsuit will be a success based on the merits of the case, the person bringing the case forward, the plaintiff, whether the plaintiff will suffer irreparable harm if the injunction is not granted, and whether the balance of hardships tip in the plaintiff's favor. In fact, that's basically what it says, that the plaintiff must show that without the injunction, the damages he suffered will far outweigh the damages that the defendant will suffer if the injunction is issued, and the injunction finally will have a favorable impact on the interests of the public. But we don't see anything in there talking about locking people up, jail time, prison sentences, loss of liberty, because that falls squarely in the realm of criminal. Now, let's go back. We're looking at the only place that United States district courts have any jurisdiction is in 18 USC 1964 C. Okay? United States district courts. They're granted civil jurisdiction to issue injunctive relief. No mention of criminal activities, no mention of criminal penalties, civil in jurisdiction. Civil jurisdiction. Okay? Now, so what does that do for us? Okay? Well, first of all, it's a huge, gigantic problem for your people in your federal legislature, your congressmen, Hatch, used to be Bennett, Lee, Bishop, all you my hey, Fukushima. Stop. Quiet. Quiet. I'm trying to do this here. Okay. So, anyways, gives us a perfect opportunity to challenge jurisdiction. Now, they can't establish criminal authority, criminal jurisdiction in any kind of way in United States District Courts. And the District Court for the United States, okay, which was granted original jurisdiction, okay, District Courts of the United States, okay, those are the federal courts for the state zone, but they aren't the one that they use out here because those can only be applied to federal employees. Can't they? So, now I'll come back to this. I'm gonna have to edit this out because of my dog, and I kind of lost my train of thought there. But we're talking just a little bit about what that talks about, what that really means. There's no regulation for 18 USC 3231. So we can do FOIA requests. Once we start getting that, there is the United States District Court is not the proper forum for prosecuting violation of Title 18. Because the United States District Court does not show up in 5 USC 552 or 18 USC 3231. Those are the only two areas that they could possibly get any kind of criminal jurisdiction. They operate. They don't. The only jurisdiction they have is civil, under the Civil RICO sections, 1964. Okay. That's a huge, gigantic problem. Now, start understanding a little about jurisdiction, challenging jurisdiction, what happens, okay? If any tribunal finds absence of proof of jurisdiction over person and subject matter, the case must be dismissed, okay? If a court acts without authority, its judgments and orders are regarded as nullities. They are not voidable, simply void. And, more importantly, they form no bar to a recovery sought. So you can start pursuing recovery for damages for your loss of liberty, their faults, they're operating without proper authority, even prior to a reversal in opposition to that, your challenge, okay? All persons concerned in executing such judgments or sentences are considered in law as trespassers, okay? Violation of known duties, okay? So we'll talk more about jurisdiction, but the number one thing you need to understand, jurisdiction cannot be assumed. It must be decided once it's challenged. Must be clearly shown. Now, United States District Courts cannot show that they have criminal jurisdiction at all. Which means if they're going to try to bring us into that forum, we can challenge that jurisdiction. That case must be dismissed. Also means if you know people that have been prosecuted there, all those sentences are voided. Not voided, they are void, period. Okay, they're nullities. And you have a huge, gigantic opportunity for damages. You know, I say these things only because it's just the tip of the iceberg of the problem that we're operating under. Your federal government for the United States is a criminal organization, has been for a long time. Look at what they've done. Look at what they do, even now knowingly prosecuting people in the wrong court that doesn't have constitutional authority. They do it anyways, don't they? That means everybody in Justice Department, any of those agencies that were involved in any of that case, even the jurors, you have a duty to know law, don't you? Simple reading, it's right there. Okay, it's been around for, this was exposed back in 1996. They're still doing it. Okay. They need to establish jurisdiction. So this becomes one of the very first things that we use in establishing, building our defenses against federal actions against us in the areas and places that are going to be having to bring us to adjudicate these particular issues. Number one, they don't have criminal jurisdiction in the United States District Courts. They have those in district courts for the United States, but those aren't out here. They have any of those out here in the States? No, they don't.